One of the things that we found in the last article of that Jurymetrics special issue is that there are relatively three incentives for why the successful programs work. And it's because incentives align in one of three ways. And the first one is government creates this soft law to set expectations, and companies follow because they know that if they, organizations follow, because if they don't, there are consequences. Hard law will come. The second is entities create soft law to avoid hard law. There's various cases of this. For example, the ESRB, which is a gaming labeling system that the gaming industry created in order to avoid congressionally mandated labeling of video games. That's the second one. And then the third one is self-interest. The organizations create these soft law programs and implement them because they know that it will benefit them in some way or another. It will provide them reputational benefits. It will provide them protection against litigation, as Gary said, if they implement these standards. So it's always something that benefits them. So these three incentives are something that need to be thought about when creating or designing soft law programs, because the incentives don't align, the programs won't be implemented.
So building on what you said, Carlos, that there are some might have an appetite for soft law to circumvent or to avoid hard law. Is there a risk then that hard law falls behind and lags behind in its finesse to be able to govern these technologies? And when you're looking at, replacement of, you looked at 634 up to, I think, December 2019. So of course, it's been quite a few, that has come out since. That's a lot of programs and initiatives that has been launched. You could say that there's a very strong appetite for the soft law instruments. Is that because of the void in hard law? Is it because the incentives are not there to do so? Or is there, what do you think is the main reason why we are at this soft law stage of how we govern new and emerging technologies, particularly AI?
The way Gary and I study governance is that we're cognizant of the pacing problem, and the pacing problem is that government always takes more time than technology to react, and that's just because technology requires money and ideas to happen, and hard law governance requires much more. It requires that legislators agree, that the executive agrees and signs, that the interests that are out there also agree. It takes so many individuals for legislation to occur that by definition it needs to be slower. The problem with AI is that it's so encompassing in the methods and applications it touches upon that right now we're ending the learning stage of AI, where when you talk about AI, usually a couple of years ago, people would ask, I don't really understand it yet, or where is it, or where have I seen it? And we're ending that phase already. Everybody and their parents know about AI because they have either a speaker, a smart speaker in their house that talks to them, or they use it intuitively, or their kids have shown it to them. Now we're going into the phase where, okay, there's more public interest and legislators are now paying more attention. So this pacing problem will always exist. What soft law allows us to do is it allows us to either find ways to substitute, complement hard law that is not there. And it's not there, not because there's no appetite for it, it's because it's very difficult for it to exist. So the only reason that we found out that soft law has been prevalent is because of that gap, that increasing gap. Now, most of our soft law programs were created, about 90% were created between 2016 and 2019. Mind you, we found the first soft law program in our database created by a foreign government in 2001. But between 2001 and 2015 or 16, maybe 20 soft law programs were identified by our group. Now, our study has plenty of limitations. We focus mainly on English speaking programs. We did use Google Translate to translate programs that we found out there that were not in English, but the things that we found are very recent, which means that starting in 2014, 2015, these programs began to be created in the minds of people. And we don't foresee any stopping in the creation of this soft law. I wouldn't be surprised if 200 new programs existed or were created between December of 2019 and now. But unfortunately, the governance of it all through hard law will be very slow. And as Gary mentioned, the European Union will take a couple of years to finish their draft on AI regulation, which is completely normal.